SJC-10374, Commonwealth versus Arrington.
Good morning, Ms. Sankar.
Good morning. For the record, my name is Assistant District Attorney Shelley Ann Sankar. I'm representing the Commonwealth in the case of Commonwealth versus Lucian Arrington. I was also the trial counsel of Commonwealth v. Arrington. The issue before the court today is whether Judge Duce Gomez erred in excluding prior recorded testimony of a now deceased victim. The Commonwealth suggests that she erred in her discretion. She erred as a matter of law in allowing the defense counsel's...
So do you agree that she had discretion actually to exclude this?
She did have discretion, Your Honor, but the Commonwealth would suggest that she abused her discretion. She erred since the requirements for prior recorded testimony were met in this case.
What's the closest case for for us concluding that there's an abuse of discretion in a situation like this?
I'm not certain, Your Honor. However, I know that the most recent case, which was decided by this court,
yeah, but that wasn't an abuse of discretion, correct?
That's correct, the Hurley case.
Well, was she under the influence of drugs when she gave her testimony?
She was being medicated. She had stage 4 lung cancer, bone cancer, as well as brain cancer. So she was receiving pain medication. However, it's clear from her testimony that the medication did not impact her competency to testify. And during the pretrial detention hearing, that wasn't an issue. We had the pretrial detention hearings approximately 12 days before she passed away. And Judge Leroy at the pretrial detention hearing...
Well, let me ask you this, because there were originally 2 charges here. They were brought on separate occasions. The first was assault and battery, and the second was the violation of a restraining order, and that's actually what prompted the dangerousness hearing.
Yes.
You would like to try the assault and battery case, and obviously you need this testimony to successfully prosecute that case. Is that correct?
Yes.
What happened to the violation of the restraining order case?
Both matters were scheduled for trial in the defendant in August, and the defendant ultimately pled guilty on the violation of restraining order case. But
so what you have is you have just the assault and battery, and isn't it the case that, in fact, there was no cross-examination on the assault and battery at the dangerousness hearing?
That's correct, Your Honor. However, it's Commonwealth's position that counsel at the time certainly had ample motive and opportunity.
Did they really? She wasn't even his lawyer on the assault and battery.
Right.
That is correct. However, the assault and battery case was also scheduled for a 58 hearing for the motion to revoke bail. So both dockets were actually before the court on that particular day, and counsel at the pretrial detention hearing also argued the 58 hearing as well, argued the motion to revoke bail and asked the court to deny the Commonwealth's motion.
So are you saying that if she had a motive, and I'll assume for the purposes of this that she had a reason to ask about the assault and battery, she clearly did not. I mean, the questioning is about 2 seconds long. You say that he, in the assault and battery case where she really wasn't even his attorney, is bound by that?
Yes, Your Honor, because the issues regarding the assault and battery case would be the same issues regarding the violation of restraining order case if the matter were ultimately tried, in that if counsel was to attack the victim's credibility on the violation of restraining order case, that would also be relevant on the assault and battery case.
Why? I mean, these are 2 separate incidents, separate in time, right?
They are.
I mean, just credibility generally would be an issue. Therefore, anything having to do with credibility that might have been raised in this hearing means that there was an opportunity to cross-examine on all issues.
Absolutely. And in fact, in her cross-examination of the other witnesses during the pretrial detention hearing of the victim's mother as well as the defendant's son who testified on his behalf, in counsel's cross-examination, she tried to impeach the victim through these other witnesses as well, but she chose not to.
But she chose not to with respect to the only witness to the assault and battery, who was clearly, from the transcript, suffering from the medication, memory lapses, inability to sort of respond in any kind of prompt fashion. right?
Well-
She was clearly
well, she-
suffering from that, and counsel said, I will only take a minute. I don't want to aggravate the situation.
But that limitation was just by her own doing. It certainly wasn't any limitation that was placed by the court or by the witness herself.
No, but don't you think the judge, in determining, exercising her discretion in determining whether it was a sufficient opportunity under all of the circumstances to cross-examine the witness such that it should be admissible at another trial, do you think the judge couldn't take those things into account in determining whether to exercise her discretion?
Well, the judge who conducted the 58A hearing was actually Judge Leroy, who initially allowed the testimony to come in.
But on reconsideration decided, no, actually, this is a trial judge decision.
This is a trial judge's decision, and then it went before Judge Jusek Gomez, who, in the Commonwealth's position, erred in her discretion, since it was originally allowed in by Judge.
But he reversed that himself. I mean, it wasn't that he said this, but I'm saying something different. I mean, he vacated that order, didn't he?
He decided that it was an issue, since it was a motion in limine, it was an issue that was best addressed by the trial judge.
Did you ever consider taking her deposition since you knew she was so ill? Or do you think that it was there was just not time?
We didn't think that there was time, and this matter was scheduled for a dangerousness hearing, so the issue that the Commonwealth thought it should deal with first is whether the defendant posed a danger to her such that he should not be released.
But it was clear that she was not going to live until trial, or that it would be very close. So I just wonder if you ever considered taking a deposition in cases such as that.
No, we didn't consider taking deposition because we attempted to preserve her testimony by having the pretrial detention hearing.
Risky, much easier and simpler. I mean, then if you take her deposition, then it's preserved.
Ms. Sankar, may I
Yes.
ask you a question? With respect to the hearing before Judge Loy, and you were there because you're doing the examination, at one point you asked her, can you tell the court what he was saying? Kim, can you tell the court what he did? Her answer is, I'm sorry, my medicine is kicking in on me. It's not in the transcript, but doesn't that suggest that something is happening with her medication?
I believe the reason that she may have answered that way is because there was a delay in some of her responses due to her medication kicking in. However, her responses were still intelligent. She answered the questions that were posed to her.
I understand that. I mean, you've got a question and answer. The question is, to what extent are the answers reliable? It's not a question that she's not answering. And then at another point, Judge Leroy, again, on a black and white transcript, it doesn't look as if anything's happening. He grabbed my pump, her medication pump. He grabbed it, yes. What did he do with it? And then the judge says, Commonwealth, you have to make a decision. And again, this suggests to somebody who's not there looking at the record that something is happening in the courtroom.
At that time, she was delayed in her responses.
Do we look at the question of competency as it relates to confrontation any differently than we look at competency as it relates to the hearsay issue?
Well, I think for the confrontation clause, counsel, again, the rules suggest that, or the rules dictate that there has to be motive and reasonable opportunity for cross-examination, which counsel had at the time. The defendant
But
had.
it looked like the lawyer backed off. There are a couple of sentences that the lawyer expresses when he, I think it was, approached the witness for cross-examination. It sounded as though he was being more gingerly than he otherwise might have been.
And that could have been a strategic measure on the defendant's part as well, knowing that
He didn't want to alienate the judge because he was about to attack a witness who was heavily medicated, dying of cancer.
Or knowing that the victim was dying of cancer and that she probably wouldn't survive until the trial date, it could have been a strategic measure not to cross-examine further so that the Commonwealth wouldn't be allowed to have the prior recorded testimony to
Yes,
come
but
in.
you have an answer to that. Take her deposition. So then you're making the argument that the defendant controls the cards by not cross-examining her. But the answer to that is then very simply take her deposition.
Well, in the Commonwealth's point of view, the testimony was preserved by the 58A hearing, which would have then tried to...
But that's the Commonwealth's view. It may not be a court's view, as happened in this case.
I understand.
As to the motive, does it matter, or should it matter to us, that in this particular case, the defendant was charged with assault and battery, was placed on bail, and now was being brought before the court on a 58A hearing because of the restraining order violation? Does that mean that the motive then is to attack the restraining order violation and not touch the A and B, since before that was not enough to warrant his detention?
Well, since both cases were before the court that day, the assault and battery as well as the violation of restraining order, the defense counsel who represented the defendant that day was answering to both cases.
How was he, you've said that about 2 or 3 times, how was he answering to the assault and battery charges?
Because that day, it was also scheduled for a 58 hearing, which was a motion, Commonwealth's motion
Right,
to revoke bail.
But that has nothing to do with the underlying offense. That has to do with whether or not the person has committed a crime while on release.
That's correct.
In other words, violation of the restraining order.
Committed the new offense, yes.
So why is that the underlying assault and battery charge? I mean, whether or not somebody's violent and therefore, a court can conclude should forego bail is a very different inquiry than did you commit the underlying offense.
Since the testimony that was elicited from the victim also included the assault and battery charge, because the Commonwealth was trying to persuade the court that this defendant, Mr. Arrington, is a danger to the victim because he committed first the assault and battery charge, and then she obtained the restraining order against him, and then he committed the violation of restraining orders. So the history, the Commonwealth was showing the entire history between the two parties to show that he is a danger to her and should be held.
Did the defendant have a lawyer for the assault and battery charge at the time of this hearing?
Yes.
And was that lawyer notified that there would be a hearing to revoke bail in this case, in the A and B case?
Yes.
And where was the lawyer?
I know that the lawyer was present earlier that day, but she was also advised that Attorney Woods, who was representing the defendant on the pretrial detention hearing, would be present.
Did the lawyer in the assault and battery case get discovery in the assault and battery case?
She did.
What about the lawyer that was representing the defendant in this case? Did that lawyer have discovery for the assault and battery?
She did. She had police reports as well as photographs that were taken.
You discussed,
that were made available
you
to her.
discussed a great deal the reliability of the testimony for its admissibility. But hasn't the United States Supreme Court indicated its dislike for the reliability test in both Crawford and Melendez-Diaz?
Well, in this particular case, Crawford wasn't an issue in the court below. And although the prior recorded testimony is in fact testimony, the Commonwealth's position is that it was taken under oath. It was subject to cross-examination. The defendant was represented by counsel. So it's admissible.
Well, let's assume for a moment that we conclude that it meets the Crawford standard. I'm not saying that's what we will conclude, but let's assume we do. Does that end the inquiry? Can't the court still make inquiry as to whether or not the testimony was reliable enough to warrant being admitted without the witness present?
I think the court can certainly make that or have that discretion. However, it's...
Well, I'm looking at page 43 of the transcript, a point similar. Well, page 43, the court says, Commonwealth, you have to make a decision. So obviously the witness is having trouble answering the questions. And then she says, he smashed my head with my pump. The court then says, testimony given when the person is in that cognitive state cannot be found to be reliable. What's the court referring to? Her current cognitive state, the witness's current cognitive state?
I believe so, because, as I stated, her responses were delayed. So she did answer the questions. She answered them coherently. She answered them intelligently, but it took her a while to be able to answer them.
Okay. Thank you.
So for all these reasons, Your Honor, the Commonwealth would suggest that Judge Giuseppe Gomez erred in excluding the prior recorded testimony since it met all the requirements to, as a hearsay exception, to render it admissible, and the Commonwealth would then rest on its brief. Thank you.
Thank you, Ms. Sankar. Good morning, Ms. Dolvin.
Good morning. May it please the Court, Madam Chief Justice, Sarah Dolvin here on behalf of Lucian Arrington. Your Honors, I obviously do not, as appellate counsel, share the similar advantage of my sister as having been present at these proceedings. And obviously, this is a situation where a lot happened outside the purview of a transcription. However, I would point to the record. The attorney who was present, Attorney Woods, this isn't a sworn affidavit, but it was included in the record appendix of the Commonwealth, a letter from Attorney Woods basically stating that she did not believe that the defendant, that the witness, Ms. Mann, was competent at the trial.
But do we even have to get to that? I mean, don't we have to find that the issue is substantially similar, and what I see the Commonwealth doing is objecting, it's not connected. You know, this is a revocation of bail at best, violation of the temporary restraining order. I mean, there's passing reference to the underlying allegation of assault and battery, but that's about it.
Yes, I would agree. And again, at a disadvantage, or perhaps as appellate counsel, I could be accused of armchair quarterbacking at this point, but the record, as it shows, these proceedings were erratic at best. It appears that this was sort of a desperation move on the Commonwealth to get this case in, knowing that this woman was gravely ill.
No, the man is continuing to contact somebody in
Yes.
violation of the restraining order. It's perfectly clear that what the Commonwealth is worried about is that he's continuing to contact her, notwithstanding the fact that there's a restraining order out against him. He's been warned. And so they want to make sure that he can't continue to contact her. That's what's clear.
Yes, that is very clear.
And they are
agree.
trying to go in through a dangerousness hearing, not unreasonable, because if he's out on probation, and he's out on bail, he continues to contact her.
Right, and in the context of a domestic abuse, obviously the issue of dangerousness and whether the victim feels safe is important. However, again, from the record, it appears that Judge Leroy was unclear as to the nature of these proceedings. There was some back and forth about the dockets and what case was on. Again, the attorney Roberge, I believe her name was, who was representing Mr. Arrington on the underlying assault and battery charge, was not present. And in fact, again, there's this communication between attorneys that's contained in the record between Attorney Woods and Attorney Roberge regarding
Could I
this
ask you
case.
this question? In connection with the, had the Commonwealth moved earlier for a dangerousness hearing? Because at the time that the restraining, this restraining order that's at issue here was being sought, the alleged assault and battery had already taken place, correct?
That's correct, yes.
And the judge knew about that.
Yes, he did.
So the Commonwealth had not moved for a dangerousness hearing at that time.
I believe that the Commonwealth had moved for a dangerousness hearing only, in my reading of the record, only in regard to the violation.
New
of the
offense.
restraining order.
Okay. New
Yes,
offense.
yes.
Now, if you look at the transcript, even though there is no cross-examination on the underlying assault and battery, which the Commonwealth, that testimony the Commonwealth now wants to use, there is a lot of testimony. I mean, she was directly walked through the entire assault and battery as part of this hearing, right?
Yes, she was.
And that wasn't, I mean, that was relevant to the question of whether he posed a danger to her.
Yes,
The
it
prior
was, indeed.
violent interaction. So why wasn't it something that she, as counsel in this hearing, had an opportunity, an adequate constitutional opportunity to examine?
Well, Your Honor, I would argue that it's at this point that the competency really comes into play, in that the record is replete with indications that this woman was very heavily medicated. She, there are at least 2 or 3 instances on the record where, as referred to earlier, the judge said, Commonwealth, you have to make a decision. Someone in
But
this cognitive state.
Your sister's saying that she may have taken a long time to respond, but her answers when she responded were accurate. Do you dispute that?
It appears on the record that a lot of her answers were accurate. However, there were some that were non-responsive to the question.
But that happens in a lot of cases.
Well, yes, that's true.
Was there a request for a competency hearing as to that witness in this case?
Was there ever a request for a competency?
Yeah.
No, not that I know of.
So competency was not made an issue,
No,
by,
it
at
was
least by
not.
counsel.
No,
Mr.
it was not.
She had passed away before there was
She
trial.
she passed away even after after this. They scheduled the pretrial hearing. She passed away even before that. It was
Ms.
within 2
Dalvin,
weeks.
in a case such as this, where there's a very, very high risk that somebody will not be alive and will not be able to testify, or even if she's still alive, will not be able to testify, is it the Commonwealth who has the burden to get a deposition, or is it the defendant's burden to take the opportunity that may be the only opportunity to cross-examine on the underlying offense? Who has the burden?
I would argue that the Commonwealth has the burden, given that down the line, it's the burden of the party who wants to introduce the out-of-court testimony, who has the burden of proving all the prongs of the test. Therefore, if this is, and as appears from the record, this is a situation where the parties were aware that this woman was suffering a terminal illness, looking down the line, wanting to preserve her testimony, the Commonwealth then had the burden to make schedule a deposition in order to do that.
But how is this any different than a probable cause hearing? The Commonwealth put her on the stand. They, as Justice Cordy mentioned to you, walked her right through the assault and battery, which is what would happen at a probable cause hearing, and they were she was at least available for cross-examination. Why isn't this the same as a deposition? I mean, if she was going downhill, do it now. Why wait?
Well, that is the Commonwealth's argument. Again,
what's your answer? Why wait? I mean, why wasn't this an adequate substitute for a deposition?
Well,
because the opportunity to adequately cross-examine her was not there by virtue of her state.
Well, is
as
there any
Judge
reason to
Ducey
believe it would have been any better during a deposition?
Perhaps she would have had more, there may have been more availability for some accommodations for her. It's not such
Well,
a
I suppose one argument is at this hearing she's trying very hard to get an order entered that's going to lock him up so he won't be able to contact her, presumably if she's having a deposition taken in circumstances where she might be more comfortable, and it's simply a factual recitation. There might be a difference. I don't know.
Well, can we go back to what you answered to my question a few minutes ago? So you agree many of her answers were accurate?
They appear to be accurate, yes.
So
How do you know that? I mean,
Let me clarify. They appear to be
responsive.
responsive, yes. Thank
well,
you.
there's a great difference between responsiveness and accuracy, I assume.
Yes, there is a great difference. And again, I believe it should be noted that when all was said and done in this hearing, her testimony was not really credited by the judge, I would argue. He
revoked bail.
He revoked bail, and he did impose conditions. He never made a finding of dangerousness. In fact, he questioned whether there was a nexus to connect these events, which he had, in my reading of the record, he was referring to the phone calls, with dangerousness. Never made an explicit finding, expressly discredited the mother's testimony, discredited the photographs that were introduced of the injuries, which were taken 4 days later, and didn't really credit, again, he never stated anything explicitly, which is in part, I think, why we're here. He never really credited her testimony.
What was the closest statement that the judge made to the effect that that witness, the victim, was not reliable? Her testimony was not reliable.
I think it was that statement that he said, Commonwealth, you have to make a decision. Testimony given by someone in this cognitive state cannot be found to be reliable. Well, why he didn't act further on that at the time, obviously I don't know.
But was that in response to how slow she was in responding? Isn't that what you said?
It's my understanding, and again, from looking at the letter submitted by counsel who was there that day, defense counsel, she was sleeping. And again, practically, that is something that I know of as being, if you're on morphine, that happens. She had to be prodded to be awakened. So there was a long delay, not only because she may have been processing more slowly due to the medication, but she was actually asleep at times. And actually, defense counsel states that she should have. She mistakenly did not object and raise this issue of competency at the hearing, and indicated to the counsel for the underlying charge that she would be willing to. In fact, she was indicating that she said that these cases should remain separate because she was indicating, you may need to call me as a witness. And while I didn't preserve my objection on the record, I would be happy to testify as a witness that she was not competent during that hearing.
Does the record indicate whether the counsel who was there at the 58A hearing, and maybe Ms. Sankar said this, but does it indicate that she actually did have all the underlying police reports and everything else with respect to the A and B, the separate case?
It was my understanding that she was provided discovery.
For which case?
For the underlying assault and battery case. Was she provided discovery for the A and B?
Yeah.
Yeah, both.
Yeah, I think that she was provided discovery for both.
With
On
respect-
that day or when? You mean as part of the restraining order case?
Actually, that I'm not quite clear on from the record. Commonwealth would be better able to answer that question.
I'm sorry,
yes.
go ahead. You can finish your answer. If you
As I said, the record indicates that there was a lot of confusion in the initial moments of the hearing about this case and procedurally which docket was on, and so it seems like it was unclear from the outset.
But as I understand, that confusion was ultimately resolved.
Yes, it was ultimately resolved.
There were two issues. One, whether bail should be revoked because he had committed a new offense while on bail and thereby posed a danger. And the second was, with respect to the new offense, the violation of restraining order, whether he should be detained without bail, essentially.
Yes.
Now, what you're telling me is the judge decided not to detain him without bail.
Correct.
Under 58A, but revoked his bail under 58 because he had committed an offense while out on release and posed a danger to someone. Is that correct?
What he ended up doing was...
Is that what he did? He revoked bail and then set new bail because, explain that to me.
Well, again, it's not the clearest record. It's my understanding that he did not revoke bail per se, but that he released Mr. Arrington on conditions that he wear an Elmo bracelet.
I understand the conditions, but were those the conditions of his release on the A and B under this new bail?
This is how I read this record. Again, I have looked it over many times, and it does not seem clear.
helpful.
It seems to me that the decision the judge ultimately made was on the A and B. He did not address the underlying case and the dangerousness, and imposed the conditions on the basis of the several phone calls. At one point he says, you're an adult, you can read, you should know that you...
One thing is clear, you violated the restraining
Exactly,
order.
exactly.
And therefore, that was a basis to revoke his bail, essentially under 58.
Yes, essentially, yes. And prior to that, he had made several indications that he did not believe that the Commonwealth had met its burden in terms of the dangerousness issue.
Ms. Dolver, may I ask you this? First, we have, as you pointed out in the Commonwealth's brief, the letter from Stephanie Woods, who was the counsel at this hearing that we were discussing. First of all, what is the status of that letter? In other words, what weight do we give to any statements made?
Well, Your Honor, given the fact that trial counsel is present to argue, I was making reference to those letters as part of the record that was included in the Commonwealth's.
I understand that. Did Judge Ducek Gomez have this in front of her?
I don't believe that she did.
It's irrelevant. The Commonwealth put it in?
Yes, Commonwealth put it in. It was not something before.
Separate question. In its memorandum of law in support of its motion to admit this testimony, the Commonwealth stated, and I quote, it describes the lung and brain cancer under the care of hospice. She had a pump that squeezed medicine. Ms. Mann became comatose and suffered seizures 2 days prior to the hearing. That's upon information and belief. Ms. Mann was in a wheelchair when she appeared, and due to her medical condition, the Commonwealth requested and was granted permission to lead her during direct examination. So what do we make about those representations? If the issue here is looking at Judge Ducek Gomez's decision that this testimony was not reliable for admission and a trial on the assault and battery, do we take those as representations of the Commonwealth, or do we disregard those?
I think they can be taken as representations of the Commonwealth. However, they were not. They're other than in an affidavit of the Commonwealth of my sister. There was no evidence clearly put into the record to support any of those representations.
But
these were representations made by the Commonwealth to the court in making this decision.
Yes, yes.
But there was evidence other than the victim's testimony, I take it, upon which the judge could have revoked bail from other witnesses.
Yes, primarily from her mother. However, the judge discredited the large proportion of her testimony.
Well, if the judge discredited the mother and the judge found that this witness, assuming that it was a finding, that the victim's testimony was unreliable, on what basis could the judge conclude that there was a violation of a 209A order for purposes of revoking bail?
That, again, is a question that I have not been able to answer.
The son testified.
Well, yes, the son's testimony. He did credit the son's testimony. He credited that son's testimony regarding the fact that she
prior
did not...
subsequent contacts and all of that
Yes.
came in right through the son.
Yes, so that's where it came in, yes.
Thank you, Ms. Dolvin.
Thank you very much.